to appeal a break?
Yes.
All right. Are you on probation?
No.
Are you on parole? All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will? And because you believe that you're guilty of these offenses?
Yes.
May 20th, 2023, at the location of 3480 Johnson Road, Saline Township, Washtenaw County, State of Michigan. What happened between you and Catalina Phillip that makes you think that you're guilty?
We were having arguments and a little bit of fighting, both of us, not only me. I pinched her.
You did what?
I pinched her.
You pinched her. Okay. So you were arguing, you were fighting, and then ultimately you pinched her? All right. Did she give you permission to do that?
We didn't talk about permission before.
Okay.
Never happened.
Well,
No, so it's basically no, she didn't. No.
okay, and she didn't give you permission to pinch her at that time, did she?
No, she didn't.
And you did that on purpose?
I guess. I mean, yes. Yes.
What do you mean you guess? I mean, it's really simple. Did you pinch her on accident, or I don't.
No.
Counsel, did you want to do the voir dire?
Yes.
Because please.
Okay, on the date and time that the judge did indicate, again, you were at the home of the home in Saline that you and your wife reside in, correct?
Correct.
Okay, and you had been involved in an argument with your wife, correct?
Correct.
And throughout the course of this argument, as you indicated, you had pinched her, correct?
Correct.
And during that pinch, you clearly you did not have permission to pinch her.
Correct.
Okay, and so based on that, did you, in terms of you not having permission to pinch her, you indicated that you believe that she gave you permission, correct?
Correct.
Okay, however, it's fair to say that the police came to the home, correct? Okay, and it's true to say that you had also made admission while you were in the vehicle that she had touched her without her permission, correct?
Correct.
Your Honor, I have nothing. I'm satisfied.
Hold it, but did he say that at the time he thought he had her permission?
At the time of this argument, and at the time that you had contact with her in which you pinched her, did you believe or did you know that you did not have permission to pinch her at that specific time that you had touched her and pinched her? You did not have her permission. Is it correct or not? To pinch her. Okay, Your Honor, I'm satisfied.
Okay, well, and when the police trooper showed up, correct? The police showed up? What happened with your interaction with the police?
Should I describe everything or?
Your Honor, may I have one?
Yes, please.
Thank you. On that date, you had encounters with a police officer, Jones, correct?
Correct.
And also another police officer, a trooper, actually, Nathan Dillon.
Yes.
Okay, and at some point in time when the police had come to the home due to the fight that you and your wife had been having, did the police at some point in time tell you to come with them?
Yes.
Okay, and did the police also at some point in time attempt to put cuffs under your back? Okay, so during that process of while the police were investigating this issue with you and your wife, did you walk away?
No.
Okay, did you in any way, shape, or form oppose the police at any point in time during their interaction with you? Did you fail to obey their lawful commands of either stopping, not moving away from their area?
Yes, I think it's.
Okay, you can't think, either you did or you didn't.
Yes.
Okay, well, and so in a way, did you also, and not in a way, but did you oppose any other lawful commands, such as, again, did they indicate for you to stop? And did they say stop, 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 and you kept moving at some point in time during this interaction with the police?
Yes,
Okay, and you observed them to have a police badge on them, correct?
correct.
And they were in a blue uniform?
Yes,
Okay, so you were aware that they were they were Michigan State Troopers at that time?
yes, of course.
Okay, and they were affiliated, they were law enforcement? Your Honor, I'm satisfied.
Well,
Your Honor, the people aren't satisfied.
pardon?
May I voir dire?
Yes.
Mr. Phillip, when the police were trying to arrest you, did you hit one of the officers?
No,
Okay, and are you aware that one of the officers was bleeding from the face? Are you aware that one of the officers was bleeding from the face?
yes, I was aware, and I even asked him what happened, and he told me, he got,
Okay, and so were you thrashing about when they were trying to arrest you? Were you making movements when they were trying to arrest you? No,
yes, I guess I.
not, did you or did you not? Okay, I don't think we can take this plea, Your
I
Honor.
don't either. I'm ready for an exam.
Okay,
Troopers are still here.
So I admit I didn't know what's happening. I was shocked.
Sir, let me ask you a question.
Yeah.
They have voir dired you. When the officers were the troopers were trying to arrest you, correct? And during the course of that arrest, did you strike one of the troopers in the face?
So from I remember, I didn't. From I remember. So I wasn't willing to hit anybody. I didn't want to hit anybody. Not my wife, not the troopers.
Okay, initially, I'm not asking whether or not you wanted to. Did you?
Yes, the handcuffs, their handcuffs hit the trooper didn't. He even told me that.
Their handcuffs did what?
Due to the struggle, they said due to the struggle, the handcuffs hit.
Okay, so they were trying to put handcuffs on you, right? What, they get one handcuff on you and then you moved away from them?
I had all my hands behind. And I was on the grass, not on the driveway. They put me on the grass.
They put you down.
No, they moved me from the driveway on the grass. They pushed me they took me from the driveway to the grass.
I can't get enough to take a plea, because he's not saying he did anything.
I agree, Your Honor.
Your Honor, me personally, I understand we're going to proceed to exam, but I spoke to my client and I was very direct in terms of the the nature of the incident, and he was able to make a factual basis.
Okay, that's fine. He has to tell me that. I have to be convinced that there's a factual basis. He is hedging on any interaction he had with the troopers. So I can't even get let alone a resisting. I can't get an attempted resisting out of what he's telling.
I would like to, I would like to clear.
Here's what I'll do. Apparently I don't have anything else to do. Take him back. I'll let you go back there and talk to him. But I'm not going to sit up here and try to coerce a plea. But if he doesn't, I'll say it, we can go ahead with the exam. So you can take him back and then you can go back there, Miss White, and talk to him.
Ms. Weidling, I have to go help with a motion in the other courtroom. Will you please excuse me? On behalf of the people.
Okay. Sir, you had an adequate opportunity to speak with your attorney.
Yes.
All right. You may continue voir dire, Ms. Bowman.
Thank you. Okay, so going back to the date of May 20th of 2023, is it fair to say that while you were in the process of being arrested and a trooper with the last name of Jones was attempting to handcuff you, you pulled away at that moment, correct?
Right.
Okay, and due to the struggle that you were having with Trooper Jones's handcuffs struck the left side of his face, causing him to have suffer injuries, correct?
Correct.
Is that a yes or no?
Yes.
Okay.
Your Honor, the people would be satisfied if that is what actually happened, but it actually struck Trooper Dillon in the face.
I'm just referring
Okay,
to the
you're-
investigator's
all right.
report.
But it struck a trooper in the face. Right?
Yes. But the listed victim is Trooper Dillon. He's the one that suffered injury.
Okay.
Well, let me correct myself. Is it fair to say that it was Trooper Dillon,
Dylan,
who you didn't drive in the scout car with to the jail and the hospital? It was the other trooper that was struck in the face, correct? That you,
yes.
okay.
All right. Given that testimony, has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 5. Pre-sentence investigation, and counts 1, 2, and 4 are dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be
July 6th at 9 a.m. with Judge Freshour.
July 6, 2023, 9 a.m. before Judge Freshour. Bond in this matter will continue. Thank you.
Is there a way, I have 2 9 a.m. matters in Detroit that morning. Is there a later time that, say that Judge Freshour will, unless I'm just very late?
That morning, I'm gonna have my own issue running my court, so you might want to call over there because I can't tell you. There is no other time we have.
Okay, I'll be there.
So your time provided.
Okay, we only have one time provided, so what you can do is you can, I'm certain you can contact your chambers and try to see if you can work something out in terms of timing. All right,
We address bond.
sure, go ahead.
Thank you. Okay, so my client, he is 45 years old, and he actually, when he was first arraigned on this matter, he was ordered a personal bond, I believe $50,000 personal bond. From the interim of when he was placed on that bond, he was not 100% understanding of the conditions of what an actual no contact order encompasses. As a result, he did go back to the home where his wife and him live in Saline, Michigan. His wife was not present at that time. However, based on the no contact order, he was violated and his bond actually reverted to was
Well,
changed.
hold on a second, that's not really what happened.
I was gonna add more.
Go ahead.
Yes, and there's apparently he had made phone calls to the complainant. And again, I had not been retained on this matter to make sure he was aware of all the conditions of what a no contact order encompasses. I've had at least 3 2-hour meetings with Mr. Phillip in the jail, and he is very, very aware of what no contact means, in which he cannot have any telephonic, physical, any type of contact with an individual that a court imposes that order against. So, Your Honor, right, what I'm addressing right now is he is a citizen. He was a citizen of Romania. He came to this country all the way back in 2007, and he came here to pursue education plus work. He actually has a medical degree from Romania. From the time that he came to this country and to the time, the present day, until this case has come about, he has had no criminal contact, any type of prior convictions, etc. He works as a carpenter, he works as a florist. He's very, very skilled. The home that was actually built in Saline, Michigan, amongst his wife and him and his children that live in currently, he built that from the ground up. He also built a home in Livonia that is now set to be, the occupants are set to be his grandparents-in-law. And that is the home that he will go to if this court agrees to allow him for his bond to revert it back to a personal bond. I see the situation as we know what the purpose of bonds are put in place for is to A, make sure the person appears for all their court hearings, B, does not present a danger to the community or to the complainant, and C, abide by all the contact or any other orders that the court imposes. Now that this was Mr. Phillips' violation in which there was no issues in terms of any contact with the complainant, any violence, anything that would really not be in a position that he should be eligible back to go down to his personal bond status. I believe this is a situation where Mr. Phillip is very aware of the conditions and he will abide by them. He's been in jail for over 35 days, and His parents, I have to make it for a record as an officer of the court. His wife, the complainant, has texted me about 10, 20 times, begging me to dismiss this case. I'm not the prosecutor, and wanting Mr. Phillips to come back to see his children, and she mainly see the children, which she has indicated in her text message that the children are very traumatized that they've been away from their father for this amount of time. I handle juvenile matters regularly in Wayne County, and I understand there's issues that can relate to trauma when parents are separated from their children, especially with this length of time. If this man had a prior criminal history, if he was known to be a very violent person, if he was known to be a person that will not appear in court, yes, I believe this would be in a position where you would not be able to budge or change the bond. But he shows no prior history. His profile does not express any indication that he will not comply with all of the orders. I understand what he did in the past, but with my 20 plus years of experience, especially working with individuals to make sure they understand conditions that could bring them back into a position that they clearly do not want to be in, I'm requesting you allow him to be released back onto a personal bond, given the fact that I will not say to a court that, oh yes, I believe he's going to comply, when I can't even get my clients to comply with my own understanding of them understanding what's going on with their case. But he is very aware, and he does not under any circumstances want to be back in this situation. So I am requesting, given the fact that he does need to continue the contracts with the jobs that he has, to continue to install floors and also make sure houses are actually continuing with the jobs that he's resurrecting with houses and buildings. So I'm asking that you allow him, given the fact that he's been in jail 30 plus days, that he be allowed to be released back on a personal bond.
Respond.
Your Honor, I don't believe he was ever on a personal cognizance bond. I think he was on a cash surety bond. That's what at the beginning. But the reason why the bond was changed, actually, this court changed the bond. We've talked about this at numerous times. I have spoken to the victim myself, and while she has told me personally that she thinks that he needs mental health treatment, she also told me that necessarily this case is not inside his personality, but at the time she was in fear for herself and for her children and had taken her children out of school because of the violations. And not only that, after he was told by the magistrate these conditions, and it's obvious to me that being in his courtroom today and being at PCC handling this case beforehand, if the judge asks him, do you understand that? And he says, yes, it appeared that he was understanding. The magistrate went over the no contact order. He chose to break that twice within 48 hours. He just pled to the domestic violence. I don't believe that the changing a bond is appropriate until after PSIR at least, and to see what kind of treatment he needs to get into. I don't believe conditions have changed. And while I appreciate what Ms. White is saying, I truly don't believe that she can testify, that she can talk to the fact that he wouldn't do this because he had a prior attorney. Prior attorney and the magistrate told him not contact her. I also listened to the defendant's jail calls, the ones that are in English, there are not many. He refers to his wife in every single one of them. While he does not say, I will speak to her or have anyone speak to her, he does talk about her in every single one, which leads me to believe that he also might try to contact her, have these calls not been recorded. So I would ask that the bond to change, remain the same.
Anything else?
Your Honor, belief is different from actual actions and facts that can be actually addressed and looked at as factual observations. There's no beliefs that I believe this court should look at as, if it's a belief, then I know he's going to do it. If he has a track record of coming to the house, banging at the door, calling her, there is no track record of that. I have cases right now that I'm.
So why, when he went in and took a shower in the premises, did he feel a need to text her that he was in the house?
Because he was not aware of. He's from Romania. All he mainly talks to me is about Romanian law. But now he's understanding that this is U.S. law. We've talked for at least 6 hours.
But that's not what I'm getting at. What I'm getting at is he waited for her to leave the premises, went into the house, and then, at least as this court took it, we're sending communications to her, in essence, almost taunting her that he was in the house.
He was not aware of the full conditions of the no contact order. He had a police standby to take him to that home to retrieve his items. He wasn't aware that he was in a position that he could not actually stay in that home. Your Honor, I just don't see that these past actions should now follow through the present. Are past actions going to be something that he's just not going to be able to?
I have no way to necessarily judge anybody, but based on how they conducted themselves in the past, because I am not a predictor of the future. Motion for bond reduction denied. Bond will remain the same. You can bring it up with Judge Freshour. Thank you.
Please subscribe to help the channel.
In this deeply layered courtroom hearing, the judge worked through a complicated plea and bond review involving Mr. Philip, a Romanian immigrant with no prior criminal record who faced multiple charges stemming from a domestic dispute with his wife and a later struggle with Michigan state troopers. The proceeding began with the judge confirming that Mr. Philip's plea was voluntary, that no threats or promises influenced him, and that he understood the rights he was giving up. As the factual basis unfolded, Mr. Philip hesitated repeatedly, giving unclear answers about whether he intentionally pinched his wife without permission and whether he resisted officers during the arrest. His attorney had to step in multiple times to clarify that the couple had been arguing. He pinched her without consent, and he later failed to obey police commands, leading to a physical struggle in which an officer suffered injuries from a handcuff striking his face. The judge initially refused to accept the plea because Mr. Philip would not clearly admit wrongdoing, but after a private conference with counsel, he returned and finally acknowledged that he pulled away during handcuffing, causing the officer's injury. With this corrected factual basis, the judge accepted guilty pleas to counts 3 and 5, dismissing the remaining charges and ordering a pre-sentence investigation ahead of sentencing. The second half of the hearing centered on Mr. Philip's bond violation, where his attorney argued passionately that cultural misunderstandings and lack of knowledge about U.S. no-contact laws led him to mistakenly return to the marital home and contact his wife. She emphasized his strong work history, his role as the family provider, his lack of criminal history, and the emotional strain on his young children, claiming the complainant herself begged for the case to end. The prosecution countered firmly, asserting that he had violated the no-contact order twice within 48 hours, that his wife feared for her safety, and that his jail calls, though limited, focused heavily on the complainant, raising concerns about future compliance. The prosecutor insisted bond should not be reduced until after a full pre-sentence report. Despite the defense's detailed argument that Mr. Philip now fully understood the law and posed no danger, the judge ruled that past actions demonstrated a serious disregard for court orders and denied the request to return him to a personal bond, leaving the existing bond intact until the matter could be revisited by the sentencing judge. This hearing showcased the judge's insistence on clear admissions, truthfulness, and accountability, reminding defendants that hesitation, dishonesty, or misunderstanding cannot stand in the way of due process. If you appreciate these detailed courtroom breakdowns, please subscribe to help the channel.
Case of Blue Heron Point Apartments versus Melissa Ketzer.
Good afternoon, Your Honor. Christopher Borden for the plaintiff.
Good afternoon. Your name, ma'am? Thank you.
Your Honor, we had the opportunity to speak and review some documents. I learned of an additional issue that I want to review with my client. There is a dispute arising out of an amount my client charged that was above an amount for a fee in the lease, specifically an insufficient check fee. There were subsequent late fees. Essentially, what this case, the ledger boils down to is my client is alleging fees, June and July rent. I believe my client will have a different position on the fees after we talk today.
Gotcha.
And if we could adjourn it, perhaps 3 weeks, that would give us time to enter a conditional dismissal if the court would allow. And I would ask if you need to appear if we did have a conditional dismissal hammered out.
If everybody signed on a conditional dismissal, I wouldn't need to have you here. I would just indicate that there is, I'm not gonna be good at math this time of day, but there's, it's probably about 4,000, 45 maybe, somewhere around there. In escrow. So whatever conditional dismissal you have, you want to make sure that to take that into account.
Okay.
Okay.
I believe we would just word it as court, any amounts in court escrow shall be released to plaintiff and credit.
Yeah. However, I just want to make sure it's taken care of so we know that to do that.
Would you like the total?
Yeah. What is it?
$5,426.
Okay. So I was off. I told you don't let me do math this time of day on a Friday. All right. So, Ms. Cutson, did you have any questions about that?
I spoke to the lawyer. I agree with, we'll wait and get the late fees removed. So supposedly I'm only on $1,955.72. All my emails
Hold
and
on.
calls.
When you said that's what you're owing, is that after you applied the escrow?
Yeah.
Oh, okay. All right. Go ahead.
Because right now the portal is showing I owe $8,454.52.
And there's 50,
5426.
there's 5426. And what was your number again that you gave me?
The portal says $8,454.52.
So, and you haven't put, how much is your monthly rent?
My rent is supposed to be $1,800 a month.
18. And so obviously July kicked in that figure.
Right.
That year.
It's the July rent plus the EBS bill, and that includes the trash, utility, sewer, water. So that's why it came up to $1,955.70.
Gotcha. Okay. And so hold on, I just want to make sure I'm viewing this correctly. Given that there's really $1,500 or thereabouts in fees.
That's, Your Honor, I would say in dispute. And I believe my client would.
Over what period in time?
This would be since February, there's been a balance. The last time there was a zero balance was January 6th of 2023.
Whoa.
So late fees.
Yeah, I hear you, but the fees, like, how much are the fees typically a month?
So late fees are approximately $100 a month.
Yeah.
There are various utilities that are approximately $45 to $50 a month.
Paid all my utilities on time.
And Your Honor, these sorts of costs are the things that I'd like to discuss with my client.
Yeah.
I believe we're close to a settlement.
And I'm gonna say this, and it's always been the posture of this court, that certainly in certain circumstances, landlords can charge their late fee. But a late fee can't be just liquidated damages, and it can't be, which is a hard thing for landlords to realize, it can't be a penalty. Late fees have to be related to the cost of collection. There's case law specifically on that point. So maybe this will aid in your discussion with your client that what they don't want me to do, which a couple complexes have done, is to under court's order, give me the cost of what it is to collect and show that relationship to the late fee charge. I don't think they want to do that. It is an onerous task and not worth it, the benefit of any of that. You okay, ma'am? Go ahead and have a seat. You all right?
Sir, this whole thing has caused me so much stress. I had a miscarriage on Monday.
Oh,
And
I'm
not
sorry.
supposed to be here. I'm supposed to be on Bever. But
Sure, let us
this is
know.
very unfortunate. This is harassment. They have been harassing me. And I have to go through this the last few months that I'm there. This is unfair. I had to take off work and I've had a miscarriage. I had my miscarriage on Monday. I had my paperwork. I went to the doctor on Wednesday. They said that they could not see the fetus. All they seen was the sac. This is stressful getting emails that I gotta pay court costs and I have all these late fees. And I'm just like, I don't know the outcome. I've never been through this before.
Okay, all right.
This is very stressful.
All right. Hey, Miss Kessler, I'm sorry. And let me just say this. And I know it can't alleviate any past stress you've had. I'm going to tell you right now, do not worry about it. This is all going to work itself out. I'm giving very clear signals to them where my perspective on this whole thing is. I remember when you first brought up the fees, and you have to remember that sometimes people are always talking about the fees that they're charged, right? And you don't think the fees can add up and whether or not they're fair to be there. And then you find out with most people, it's not really the fees, it's that they haven't paid the rent. What I see from you and what caused me concern and why we're really set like this now is because when I asked you to, for example, put your rent into escrow, you weren't missing a beat getting it in. So that kind of thing tells me something. All right. But I would prefer that what you do is take care of yourself and we can do this. The next hearing that I set, I will not make in person. You can appear via Zoom on this if it's necessary to appear. I would hope that this can all be worked out. Okay. All right. You're welcome. Was there anything else you?
The lawyer was very kind to speak to me.
Pardon?
I said the lawyer was very kind speaking to me before. It's just unfortunate.
Yeah. This kind of unfortunate thing happened. That's my entire Friday. So I get it. I get what you're saying, and it shouldn't be this way. And you get the stress comes from the notion that the sort of that basic thing that we need in life in terms of housing. Also, that's all being jeopardized, and especially if I don't understand why it's being jeopardized. That's a problem. All right, but they've got the figure on the portal. You've got the 5,400 in escrow. You're in good shape on this case. I mean, because however it works out. Okay. You're welcome. You're not related. I probably should have asked, but I don't think to any of the
Yes, ma'am.
Ann Arbor Ketchners.
That is my family.
Okay, so I'm just going to tell you this, and it has no bearing on how I decide the case. So the very first time I called the case, I thought about that. I'm trying to think which one went. I think I went to high school with a couple of them anyway. So I called and I said, that's a unique name, but I mean, I know the folks.
Here.
Okay, so but I didn't know, right? And so I'm thinking that then I don't know which appearance it was. Who's your dad? Are you who?
Jonas Ketzner.
Jonas? No, I can't think of who I went. I can't.
Armor.
Is there a Ronald? No, it was.
Racing.
What about John?
That's my uncle.
John's your uncle. Okay, that's I think who I went to high school with. But I'm going to tell you what kind of got me was I don't remember what day it was, but my screen for looking on Zoom is over here. And I called it and I could see, I could see John's face in yours.
That's my favorite uncle.
Is it, so I looked at it, I said, yeah, she's gotta be one of those captains. I said, well, at some point, I'm just gonna ask because it was driving me crazy for a while. And I don't know if you know my sister, Delphia.
They probably do.
I'm sure they do. And I had to ask her. I said, like, how many captains are there? Because she would know better than I would. She had better memory than that. So, okay. So thank you for doing that. Because if I hadn't asked today, I would have spent the weekend like, I should have asked because I know that. And then when I would have called the case, I would have said, I would have seen the face and I would say, that's the captain. I just want to say something. So, where's John now?
Passed away.
Oh my gosh. How long ago?
Back in 2013.
Okay. I'm sorry to hear that. Okay. All right. So I'm going to put this out. How long did you think you're?
Your Honor, if we could have 3 weeks.
3 weeks. That's going to put me at 28. Is that right? All right. I'm gonna adjourn. I'm gonna adjourn this to July 28th, 2023, 10 a.m. And that will be via Zoom. All right. Then that way we can get it done. All righty. Everybody take care. Ms. Kitson, take care of yourself, please.
Car, do you need somebody to take you or?
I'm just gonna take it slow motion.
Okay.
You'll be good?
Yeah.
Okay. Don't be falling out in my hallway. You hear me? All right. Okay. Take care. Have a good weekend. 14-8.
Please subscribe to help the channel.
In this emotionally charged landlord-tenant hearing between Blue Heron Point Apartments and tenant Melissa, the case quickly shifted from a routine rent and fee dispute into a deeper examination of fairness, financial hardship, and human impact. The landlord's attorney informed the judge that after reviewing documents, he discovered potentially improper fees charged to Melissa, including excessive insufficient funds and late payment fees that may violate Michigan law, which requires late fees to be tied to actual collection costs rather than arbitrary penalties. With thousands already in escrow over $5,426. The court strongly signaled that many of the fees appeared questionable, encouraging the landlord to reconsider its position to avoid being ordered to justify each charge in detail. The tenant, struggling under months of stress, broke down as she explained that the constant notices, high fees, and eviction pressure coincided with a devastating miscarriage earlier in the same week. The judge responded with empathy, reassuring her that she had done everything correctly, especially depositing the rent into escrow immediately when ordered and telling her not to worry, as the case was moving in her favor. The judge emphasized that housing is a basic need and that confusion and fear over unexplained charges can overwhelm even responsible tenants. After both sides agreed to attempt a conditional dismissal, the judge adjourned the matter for 3 weeks, allowing negotiations to continue without requiring Melissa's in-person appearance. A touching moment followed when the judge, recognizing Melissa's uncommon last name, realized she was related to someone he once knew, clarifying that the connection had no effect on the legal decision but offering a brief, human exchange in an otherwise stressful situation. The hearing closed with the judge urging Melissa to focus on her health, assuring her that the court process would be fair, and setting the next date for July 28, 2023 via Zoom. Please subscribe to help the channel.